Good afternoon, everyone. Again, my name is Anna Hutz. I'm with the Pollution Control Agency, and I'm the manager of our Environmental and Business Assistance section. Cumulative impacts, environmental stressors, community benefit agreements, environmental justice areas. These are some phrases you'll hear over the next 3 years as the Minnesota Pollution Control Agency develops regulations to implement Minnesota's new Cumulative Impacts law. To understand what these things mean, consider decades-old permitting and zoning decisions by local, state, and federal governments. For many neighborhoods and communities in Minnesota, those decisions have led to heavily polluting industrial and manufacturing facilities being located near homes, schools, and parks. Today, as a result, too many Minnesotans are disproportionately exposed to harmful pollutants. To address this problem, the 2023 Minnesota legislature passed a law directing the MPCA to examine the combined effects of past and current pollution, or cumulative impacts, in some parts of the Twin Cities 7-county metro area and the cities of Rochester and Duluth. Specifically, the MPCA must focus on new and existing facilities requiring air permits located in or within 1 mile of an environmental justice area in the communities identified in the law. While the Cumulative Impacts law is new to many in Minnesota, facilities located in parts of South Minneapolis have been required to conduct similar analyses since 2008, and states like Massachusetts and New Jersey have also recently required them. For the first time, the legislature defined an environmental justice area in Minnesota law. An environmental justice area is one or more census tracts, small, permanent subdivisions of a county or city, meeting any of the following criteria. 40% or more of the population are people of color. 35% or more of the households have an income at or below 200% of poverty, which translates to roughly $60,000 a year for a family of 4. 40% or more of the population over the age of 5 has limited ability to use the English language, or an area located within Indian country, which generally means areas within the boundaries of a federally recognized tribal nation. In the Twin Cities, about half the 7-county metro area is in or within 1 mile of an environmental justice area, including the cities of Minneapolis, St. Paul, Burnsville, Woodbury, Brooklyn Park, and Blaine. In Duluth, approximately 2/3 of the city is in or within 1 mile of an environmental justice area. In Rochester, it is more than half the city. The Cumulative Impacts law applies to new facilities as well as some current facilities that are expanding or require a new air permit. Based on the legislature's criteria, approximately 120 current facilities, including landfills, power plants, refineries, and manufacturing plants, may be impacted by this new law. You may review a full list of these facilities on the MPCA website. A major part of the new law is a cumulative impacts analysis, which is intended to be a comprehensive look at past and current pollution burdens that affect a community or neighborhood. This additional environmental analysis will better guide permitting decisions and protect the environment and health of residents in the community. When a company applies for an air permit, either for a new facility, a project to expand the facility, or to renew an existing air permit, the MPCA will be responsible for determining whether a cumulative impacts analysis is required. If so, the agency must also determine whether issuing the permit would substantially impact the environment or health of nearby residents. There are several ways a cumulative impact study may be required, and each of them requires relevant information and important evidence to support the need for analysis. First, if the facility exceeds any benchmark or criteria, additional environmental analysis is required. Those benchmarks have not been defined or determined. The MPCA needs your active participation during this process to help develop them. Second, the MPCA commissioner may require a cumulative impacts analysis if relevant information suggests that the facility's air emissions may substantially impact the environment or health of residents. The MPCA also needs the public's participation to develop the definition of a substantial impact. Lastly, the commissioner could also require an analysis if at least 100 residents in the affected environmental justice area petition and supply relevant information. This is the third area where MPCA needs additional input to define a definition. If a cumulative impacts analysis is required, and the MPCA determines the facility would have a substantial adverse impact on the environment or health of the residents in the environmental justice area, then the company will be required to enter into a community benefit agreement before obtaining an air permit.
Todo esto va a ser requerido para la comunidad.
Community benefit agreements have been historically used in redevelopment projects. In those cases, the agreement is signed by the community and the company or developers, and the company agrees to create or adopt specific benefits for the residents of the affected neighborhood. In Minnesota, community benefit agreements were used during the construction of the Central Corridor and a redevelopment plan in Minneapolis's Harrison neighborhood. In the MPCA situation, this will be the first time the agency has used community benefit agreements. A community benefit agreement developed with active community input and participation will be a legal and enforceable contract between the MPCA and the permitted facility. The MPCA will be working with Minnesotans to develop a community benefit agreement process that actively engages and encourages the participation of nearby residents to address the specific needs of each neighborhood and community. We anticipate each community benefit agreement will be unique and address priorities within the affected community. Developing regulations to implement the new Cumulative Impacts law requires significant participation from Minnesotans and other stakeholder groups. The MPCA has approximately 30 months to complete its process. Our work is divided into several phases. We are currently in the scope and focus phase. This means, in addition to what is required in Minnesota law, the MPCA wants to hear from you on what else should be considered as we're developing these regulations. There are several opportunities to learn about the Cumulative Impacts law in this phase of the work. We are hosting 5 community meetings and an open house style format. We are also asking the public to submit comments through the request for comments process. You may do that through October 6th by using the Office of Administrative Hearings online portal. The next phase is the development phase, which starts in October and continues through April of 2026. This phase is extremely important as we include active participation to develop criteria and processes for the cumulative impacts analysis, the community benefit agreement, environmental stressors, and other items. We're expecting to hold numerous work sessions, open houses, community meetings, and other opportunities to develop these important items. Starting in May 2026, we will enter the public notice and hearing phase. This is where the proposed regulations will go through final public comment, a public hearing, and a legal review by an administrative law judge. If the judge decides the MPCA's proposed regulations are needed and reasonable, the regulations will be adopted and the MPCA can begin implementing. A lot of work must be completed during the next 30 months. We need everyone to be actively engaged in this process to help develop and implement a cumulative impacts package that works best for Minnesota. Throughout the process, we will have numerous questions for Minnesotans to help answer. Please continue to follow the conversation and progress online and by signing up for our Gov Delivery email distribution list if you've not already done so. Together, we can make meaningful progress to address pollution burdens and shape the path forward. On behalf of the entire team at MPCA, thank you again for your interest in this important work. We will now switch over to our discussion topics and comments. So if individuals would like to engage, please either use the raise the hand function, which is located under the reactions across the bottom bar of the Zoom screen, or by utilizing chat. And I'll invite my colleague Lauren in to help facilitate the questions so that we can answer them.
Hi, Anna. So it looks like we do have one question in the chat so far, asking, will sound impacts be part of this analysis, specifically impulsive noise, as it is currently not defined in Minnesota rule?
All right, thanks for that question. This, along with many other items, has not yet been decided. We don't have draft rules at this point in time, and these are exactly the types of things that we're looking to get input from community on. So certainly, I would encourage you to submit a formal comment to the record, including this. But I would like to note also that while we are encouraging individuals to submit, comments through the record, we also will be considering all things that we hear in these types of meetings, but we won't have a specific response to those comments.
Thank you. I was just going to say, it looks like we have a couple hands raised. So let's do those before we go back to the chat. Ryan Birkenholtz, it looks like you have your hand up. I've made it so you can unmute yourself.
Thank you. Yeah, just a question. I've actually been through the South Minneapolis process twice, and by my accounts, it has taken, it's added at least a year to each of those processes compared to what it should be, or what it would normally be rather. And I guess I'm just curious if MPCA's thought about like, how are we going to attempt to keep projects within a reasonable time frame? Because if that same process that's required in South Minneapolis is required for every facility, it's going to be a burden on MPCA, and I mean, you're going to need more staff and it's going to take more time. So I'm just curious what's been thought about there.
So in response to that, again, nothing has really been defined. There are a handful of things that the legislature defined for us. And those items include the requirement that we, that we develop criteria for the analysis and what would trigger the analysis. But exactly what components will be included has not been determined at this point in time. And so we are looking for input and advice on what should be included, and certainly consideration for what is the time commitment required and things like that. Maybe part of that, but we don't have that explicitly defined at this point. I would invite if Hassan or Carrie from the Air Policy Group, who are also on this call, have anything to add to that, I'd invite them to contribute more to this response. And looks like Carrie's camera came out there. She's unmuted now. There we go.
Well, I think in one part, my group is one of the group that has worked on the previous cumulative impacts under the current statute. And Anna mentioned, we're really looking at a new process for this. So it's not necessarily going to be the same one. So I think getting your input is really key right now. And that's definitely why we have a request for comment out right now. So even areas, if you have been through the process and have particular areas that you'd like to point out, I think that would be really helpful. So we're definitely looking for your comments, and all of that will be part of the consideration as we move forward and how we can do this effectively.
Yeah, thanks, Carrie. And I'll just add one thing and just emphasize, again, my name's Hassan Boucherib. I'm an engineer in the air policy unit here, working on this rule. I would just echo what Carrie said, which is if there are things related to timing in other processes, either Ryan, like you said, in South Minneapolis that you've experienced a couple of times, or you've seen in other states or other programs, if there are things that you like, that you want us to consider as we move forward, or if there are things that you don't like, what are the, in your experience in South Minneapolis, for example, what were the things that were time consuming? So we can attempt to consider those as we move forward.
Thanks, Carrie and Hassan. And I will just echo that. Yeah, if individuals who are on this call or others, have been through the process as it's laid out in South Minneapolis, we are certainly interested in hearing what the experience has been like, what information was required, those types of things, and we'll consider those moving forward. Shall we move on to the next raised hand, Lauren?
Yes, it looks like next in line is DJ Mulla. You can unmute yourself.
Hello, everybody. I'm David Mulla, resident of Brooklyn Center and professor in the Department of Soil, Water, and Climate at the University of Minnesota. And I'm going to ask about how you plan to do your cumulative impacts of air pollution with regards to transportation projects. We are experiencing here in Brooklyn Center, MnDOT wanting to build a 6-lane freeway in an area which is 60% BIPOC, people who have among the highest rates of asthma and COPD. And they are not considering the effects of air pollution on deaths and hospitalizations of the local community with regards to people who have COPD and asthma and other cardiopulmonary diseases. It's well known that air pollution in these BIPOC communities kills many more people than car accidents. And so I guess my question here is a couple of things. How would MPCA deal with projects that are already being considered, if they would at all? And the other question is, would MPCA consider not only the impacts of, like increased traffic on air pollution, but also the impacts of the traffic-induced air pollution on deaths and hospitalizations? In other words, would you work with the Department of Health? Would you combine your efforts to do the cumulative impacts, not only for the air pollution itself, but also the health impacts of the air pollution?
Thanks for that question. So I can answer kind of maybe a little bit of the pieces of it, and some of it is still unknown, certainly. As we've mentioned, we don't have, what will the cumulative impacts analysis actually entail? That is still being developed. So we are looking certainly for input on that. Specific to transportation projects, the law is specific to facilities requiring an air permit. And so I don't know how that might apply to, a MnDOT road project as a whole in terms of requiring a cumulative impacts analysis of it in and of itself. Right now, that would be outside the scope of the legislation that has been, provided. However, those traffic inputs and other sources around a facility, if there were a facility that were required to do the cumulative impacts analysis that was an air permitted facility, those would certainly be things that could be considered when we look at the cumulative impacts within the neighborhood. Not certain if that answers your question fully, but largely the pieces about who we will coordinate with, what the requirements will be, those are still under development, and that's all part of the information gathering as part of the rulemaking process. And I should add, we will be, not only hosting meetings throughout this process, but we will likely be seeking input on very specific items, such as, what should be included in terms of pollutants of concern for a cumulative impacts analysis, how should we shape that? Are there examples of other things we may want to refer to? The same for the community benefit agreement. So really, nothing has been developed at this point. There are a few things that are defined in the legislation, and we do need to stay within those bounds. But beyond that, we're really, really open to taking input from Minnesotans on what they would like to see. This is a process about shaping regulation and moving it forward. And so the rule process is to take that legislation and put it into something we can implement.
Are we ready for the next question, Anna?
I think so.
Okay, awesome. James Trice is next up on the list. You are able to unmute yourself.
All right, can I unmute and put myself on camera? Can I do that? You'd like to see my face? Anyway, Anna, thank you so much. And I want to thank the MPCA, Commissioner Kessler and her staff for doing these meetings. This is something that my team, Environmental Justice Coordinating Council, Public Policy Project, have been asking for, and we just thank you so much for doing it. We love our relationship with the MPCA. We want to continue to work with MPCA to engage communities as you are doing now. So thank you so much for that. So Anna, you mentioned something that I'm really interested in hearing more about, and that is the Community Benefits Agreement. I'm familiar with Community Benefits Agreement. I've worked on them before. They're usually legally binding documents, and it usually lays out how communities are going to be impacted and benefit from whatever happens, right? And as usually there is somebody's held accountable if the benefits are not met, those kinds of things. So I just want to know more about the Community Benefits Agreement. Who's that agreement with, between, how legally binding is it? Those kinds of things. If you could say more about the Community Benefits Agreement, excuse me, I would love to hear more about that. Thank you.
Yeah, thanks for the question. So yeah, community benefit agreements. They are new to MPCA. They are something we have not engaged in, with permittees in the past. So we are, forging new ground here. And so we certainly, need some input, need some thoughts on this. But what I can say, a couple of your specific questions, who are the benefit agreements between? And they are between MPCA and the permitted facility. That is who signs the agreement. So that's what makes them legally binding, because then that gives MPCA the authority through our permitting authority to hold that permittee accountable, or that company or regulated party accountable to what the community benefit agreement states. Now, we can't just go out and develop the MPCA and the company. We need input from community as those are being developed. And we don't think that there's going to be a template and just a community benefit agreement that is going to be applicable to every situation. We really view these as being unique and independent documents and agreements that address the specific needs of an individual community where a facility is located. One of the biggest things I think that's going to be important for us to have continued discussion about is, how do we set up a process that establishes that? What are the components of the process that will make it clear that there is space for conversation for everyone who should be included in the discussion about what does a benefit to this community really look like? And who is best to tell us what the benefit to a community is? It's the community. And so there's a lot of unknown. Like I said, this is new to us as an agency. So from a regulatory perspective, it's not something we've done before. But I imagine we'll have some pretty robust conversations and a lot of ideas coming forward. I'm hoping to hear those through our current, public process that is open for comment. But also we will have, specific meetings and work groups to talk about these. So if there are individuals who are interested in being part of those, I really encourage you to reach out to us, to connect with us, and to even comment on the formal docket that this is something I'm interested in and I'd like to follow. So yeah, what will be included? Don't really know yet, because we still need to develop that. But one of the things the rule really needs to do is establish process. Yeah, sorry. Lauren, can you unmute?
Yeah, so we're gonna take a couple questions from the chat just quickly. Stacy Boone put in, are you soliciting input from the public only or also from permit holders? And is the process for providing input different between the two?
All right, thank you for that. So we are soliciting input and comment from everyone, from the public, but also from the regulated community. We're likely going to hear from Chamber of Commerce, lots of different entities. So that is why we do, formal public notices, so that everybody is welcome to participate. And I believe we have some regulated facilities on the call today. I anticipate that they will be participating, in the public meetings as well. But part of the rulemaking process is to receive input from everybody who may be impacted or affected by a change in rule or a new rule. And so yes, it's important that we demonstrate that we've received input from everyone. Perhaps I can jump, Lauren, if you don't mind, to this comment that part of my response may be misconstrued to imply that the scope of the statute could be expanded during rulemaking, and please clarify that. So I will clarify that. The language, the legislative language says that the community benefit agreements will be between MPCA and the regulated facility, and they say that they will be required if a facility meets certain criteria that is yet to be established and the MPCA determines that there's a potential for significant impact to human health or the environment. So there are steps that are laid out in the statute. The rulemaking does not change what the statute says. So hopefully that is clear here. And if there's additional comment or question on that from, looks like John Cunningham, please feel free to either raise your hand or add that to the chat. Sorry to jump around, Lauren. I'll turn it back to you.
Okay, Anna, easy one here for you. Will this recording be posted on the MPCA's website, and if so, where?
It will be. There is a specific page for the Cumulative Impacts project. The easiest way to find it is to simply, in your search browser, search Cumulative Impacts MPCA. You can also visit the PCA website. Across the top bar, you can click on Get Engaged, and then there's a rulemaking link that you can click on, and then you can click on Cumulative Impacts. So that's a little bit of a few clicks to get you there. Either will get you there. I don't know exactly when it'll be posted. It'll take us a little bit of time to obtain the recording, but I would think within the week. I don't know if Lauren or Darren, if either of you have a more specific target for that question.
Yeah, I guess I can chime in here also and just say signing up for our email list to stay informed on this topic would be another great way to make sure that you're not missing any important information, such as the recording for this meeting. I believe we plan on sending out an email with all of this information, including additional info kind of midweek next week. So you can look out for it then for sure. But again, signing up for our email list is going to be the best way to ensure you're not missing anything. And I did put a link to that in the beginning of the chat if you scroll back. Okay, next question. We'll go back to hands raised. Sasha Lewis Norell, you can unmute yourself and ask your question.
Yeah, thank you. Yeah, so I'm Sasha, UCM pronouns. I work for Clean Water Action Minnesota and was part of the coalition that was advocating for this law to get passed. And I'm wondering if the MPCA plans on looking at other states or other places that have passed similar laws, especially given that this law that passed in 2023 was in many ways inspired by the law that passed in New Jersey in 2020, which just finished up its rulemaking. And so do you have plans to look at practices or things that have worked well or not worked well in other places that have implemented similar policies?
Yes, Sasha, thanks for that question. Absolutely. The answer to that is a resounding yes. We will be looking at both the rulemaking that is concluding in New Jersey, also the work in Massachusetts. And as was mentioned, there's a little bit of work that's happened here in Minnesota, in South Minneapolis, but we certainly will look to all other states, cities that have done similar types of things, see what worked for them, evaluate if they make sense in Minnesota, and then we'll seek input on that. And that's one of the things also, if you have knowledge of what has been done in other states and you want to supply some comments to us or some suggestions on things that we should be considering as we're developing our regulatory framework here, I certainly encourage you to do that. So thank you for bringing that up.
Great, thank you. The next hand raised is Jeff Stolenwork. If you want to unmute yourself and ask your question.
Thank you. Hi, Anna. Good to see you. Jeff Stallenwork, Duluth COA Port Authority. I'm wondering about this interim period before the rule becomes effective. Is it clear that the law is not in effect until the rule is finalized? And also, what does this mean for projects that are in the permitting process before this final rule is complete?
Thanks, Jeff. So first of all, you are correct in assuming that until the rule is adopted and effected, we do not have the authority to implement the rule. And so those components will not, there's not a lot we can do. I guess I don't even know how to answer that very well, but you are correct in the assumption that the rule is not yet effective because there is no rule that has been adopted. And then related to projects that are already in the permitting kind of process at this point in time, I'd actually perhaps defer to some of my colleagues in AIR. So I think Stephen Pack or Carrie Palmer are both on. If either of you, maybe Steve is the manager of our air permitting section and Carrie air policy. So one of them may be able to answer better than I can. So I'd invite them to step in at this time. Lauren, can you unmute Steve?
Yeah, there you go. Can you see me? I'm not seeing myself.
I see you, Steve. Thanks.
Okay, good. Good afternoon, everyone. I'm Steve Pack. I manage the air quality permit section at the Minnesota Pollution Control Agency. And I think that's a great question as far as projects that are already in process and when we have final rules, how do those rules impact those projects? And typically when EPA is implementing a new rule, they will offer some clarity on that, on when it applies, and so that is something, of course, that we could build into our rules that we're developing. So if you have thoughts on that, we would be happy to hear them and consider them when we're developing the rule.
Thanks for that, Steve.
Okay, the next question is in the chat. I'm going to read it out loud. It's a bit of a long one, so Anna, you may want to reference, but it's from Stacy Boone again. And it says, for tribes within the EJ areas, what will be the level of review/comment expected for looking at future cumulative impact assessments? Will they have opportunity or expectation to comment on all assessments in the EJ or a certain distance from the boundary? The Shakopee Sioux community has commented on/reviewed air permits that are adjacent to SMSC land in the past, and we're looking to understand if we're going to be reviewing/commenting on cumulative impact assessments as well. Thank you.
Thanks for the question, Stacy. I think there's still a bit to be determined about how the interaction with permits that are adjacent to tribal lands will look like. I think we'd be really interested in hearing from you if you have thoughts on that. And we do appreciate the partnerships that we've had in terms of reviewing air permits in the past. And there's also the opportunity for tribal consultation in our government to government capacity to talk further about some of these specifics, if that is of interest to the tribes. But we certainly welcome input from you. And I guess we don't want to dictate what your participation is to look like if that's not the participation that you want to have. So I think that this warrants some more in-depth conversations between PCA and the tribal entities and others who have thoughts or opinions on that. Lauren, I don't think I see any other hands raised, but perhaps I should address the comment here in the chat, the follow-up from James.
Yeah, that'd be great. Thanks,
Yeah.
Anna.
All right, so just the follow-up. Community benefit agreements are usually with the community because the agreement is supposed to benefit the community. Communities should be front and center in what benefits them. Government agencies and businesses should not determine what benefits community. Public Policy Project would like to work with MPCA to get input from the community about what will benefit them in the community benefit agreements in this process. Please reach out. So thank you for that comment. And yes, you are absolutely correct. The community benefit agreements surrounding various development projects and things like that have been between community or community groups and the developer or the company, whomever. The legislation does lay out the fact that these are legally binding agreements between the permittee and the MPCA. I think there is perhaps some benefit to that because that gives us the ability to enforce, but absolutely we need help in determining and establishing what is the process going to look like to develop those. You know, will there be a public notice? Will there be, you know, a required meeting? Like, what are the criteria in order to develop those community benefit agreements? And so certainly we'll reach out to you, but please also, you know, feel free to reach back out to us, because these are all the conversations that we need to have over the next many months in order to figure out what in fact the appropriate process to put in rule looks like.
In the chat, it looks like we have a question from Chuck Picard asking, on the Gov Delivery subscription page, what area would cover noise? Do we have anybody on that would know the answer to that?
Perhaps the airmail list, which covers generic or many different air-related topics, would be a place. We can follow up on that. I don't know specifically off the top of my head the correct connection there. There is also a general rulemaking Gov Delivery where you'll get notices about all rulemaking, but I will note that there is not currently a noise rule that has an open docket for PCA. So we can follow up on that. And then as it relates to, this may relate to the question about whether or not noise would be considered as part of a cumulative impacts analysis, because we did hear that earlier in the meeting as well. And so I think that's another connection that we can make here, is making sure that we include consideration for how noise impacts may be assessed. And if you do have specific thoughts or comments you'd like to share with us on that, please do submit those through the Office of Administrative Hearings docket. Just a reminder, that is open. The current process is open through October 6th. And it looks like we've got a hand up.
Yes, Sasha, you can go ahead and unmute yourself again.
Yeah, thank you. I just had a quick question about the process itself. So I know the deadline that the legislation lays out is like middle of 2026 or so. But like if the rules get drafted to the point where it feels like they are in a good spot, like sooner than that sort of timeline, would that move up the process in general? And could it be adopted before that? Or is that the timeline that MPCA has to stick to for the whole process?
We don't have to hold off. So if we are ready to go, if we have a rule draft in advance of that, we have to be to public notice with the final rule by May 26th of 2026. But it can happen sooner than that, absolutely. So we're not bound by that. We're bound by the end time, not the, not a shorter time frame, I guess is the best. And then in terms of process, the public notice that we're in right now is called the request for comments. That is simply what opens our docket officially and says MPCA is undertaking this rulemaking that the legislature required us to do. And so it's really an information gathering phase that we're in right now. But yeah, if our timeline accelerates, there's no reason that we can't move forward more quickly. We just can't slow it down. I also see a note, just a comment here from Ramsey County, that Ramsey County environmental health planners collectively recommend taking a look at EU and Canadian cumulative impact standards, and they provided us a couple of links there. So thank you for that. I would also encourage that you share those links as part of the public rulemaking docket. So not only does providing those comments officially, give them to the MPCA, the other benefit of sharing your comments through the Office of Administrative Hearing site is then others will be able to see the things that you've commented on as well, and they may be able to add to or help inform their own comments. So we really encourage commenting if you have places where we may be able to get information or data, where you have thoughts of things that we should consider throughout the process. So thank you very much for that recommendation. Yes, I just got a note here. Just to be clear, yes, EU is the European Union. I'm sorry. And another point that may be of interest is simply the fact that, the MPCA has a very close working relationship with the US EPA, the Environmental Protection Agency. And so we are getting information about other states that are undertaking cumulative impacts, whether we're talking about Massachusetts and New Jersey, as we've already discussed, or others who are considering. So we will continue to utilize other sources of information to help inform our process. But again, if you happen to know of any that we haven't mentioned here, please do share those with us. Lauren, looks like maybe we have another hand up.
Yes, we do. Jenny, you can unmute yourself.
Hi, thank you. I just have a quick question with respect to the legislation and the comments we're responding to. Most of it is related to MPCA and air staff, but I know cumulative impacts, at least in the legislation, talked about other impacts like housing and access to public transportation. So I'm just curious, are other government agencies going to be involved in developing information that feed into the cumulative impacts? And like, is the Department of Transportation and the Housing Department, are they going to be involved in this and providing information to help support or provide information for people having to do these analyses? Thank you.
Thanks for your question, Jenny. Yeah, we often, very regularly in our rulemaking projects, we engage with other state agencies. We've already connected with the Minnesota Department of Health on this. We partner very closely with them. Things like the Air We Breathe report that comes out regularly. So yes, we will certainly be connecting with other state agencies. But again, if there are particular items that you think we should consider or particular entities whom we should engage, then we would appreciate it if you could provide that to us in a comment to make sure that we don't miss it. I don't see any hands raised or any additional questions in the chat. Oh, I see one popping in right here now. So I'll go ahead and go to Stacy's comment here. Since you mentioned your relationship with the EPA, when conducting a cumulative impact assessment, are the impacts of nearby federally issued Part 70 and/or synthetic minor permits proposed to be included in the assessments, since air doesn't respect jurisdictional boundaries? Will the results of the assessments potentially have regulatory implications for those federally permitted facilities? So again, we have not defined what exactly will be included in the analysis. However, very likely we will be looking at other permitted sources. And I absolutely agree with you that air pollution does not respect jurisdictional boundaries. And so it is an important consideration for us to make. This is, again, one of the many things that we're looking to define as we develop this process. And so specific to other permitted facilities that are located within a community, I think defining, the geographic footprint that we would consider would be an important component of that, as well as what types of facilities, we should include. So again, additional information on that would be certainly welcomed and helpful to the process. And we do model nearby sources for a lot of air permits already. So this perhaps would be an extension on that or something additional. Do any of the, perhaps Carrie or Hassan or Steve would like to add a little bit more about what we currently do in terms of modeling nearby sources related to air permits? Could you unmute Steve, please?
All right. Yeah, I guess I just wanted to kind of add some clarifying comments to, this idea of federal facilities and things like that. When you think about the state of Minnesota, the permits that the agency issues, the air permits that we issue, can be put into two broad categories. One category are federal permits, also known as Part 70 or Title V permits. And we do issue those permits, and they are required by, we are required by EPA to have these programs to issue permits to these kinds of facilities, also known as major sources in the bill. And then we also have state permits. So we do issue basically all the air permits within the state of Minnesota, except for those air permits that are needed on tribal lands. So those permits are actually issued by EPA, and we don't have any, we don't have any involvement on those permits. And so when it comes to tribal areas, we're probably, we're going to have the most interaction are those facilities that are within a mile of those tribal boundaries. So I just wanted to kind of clarify that for people.
Thanks, Steve. I see Hassan's camera on. Hassan, do you have something to add there? Lauren, if you could unmute him, that'd be great.
Yeah, thank you. And Stacy, again, great question. I think the only thing that I would add is just, this is another good example of, as Anna said, we don't have what is the content of a cumulative impact analysis at this point. If this is something that you'd like to see happen, you are absolutely give us that comment, help us understand your point of view, why this would be helpful or not, what you would like, or if you would not like that, for example. Again, just the more information, the better, so we know what to think about, what to contemplate as we craft these rules moving forward.
Thanks, Hassan.
It looks like James Trice has his hand up again. James, you can unmute yourself.
All right. Just a question, and maybe this gets addressed in the comment period during the listening session, but how would this bill impact the heavy industry in communities like North Minneapolis? North Minneapolis, as you know, has several manufacturing facilities along the Mississippi River and Washington Avenue, and which, poses a serious health risk to North Minneapolis residents. It's about 12 or 13 probably companies that are there. How would this impact the permitting of those companies continuing to stay there, right? Or potentially having to move? As you know, my group, Environmental Justice Coordinating Council, along with other activists in North Minneapolis, were instrumental in getting rid of northern metals out of North Minneapolis. There are other companies that are there that are just at or below violating air quality standards. This is something that we've been working on for a while, that this bill came to be because of the fact that this heavy industry is there, and the cumulative impacts of those pollutants are impacting our community. How does it impact the future of those companies? Will at some point they have to move out, or is it just for future companies that are polluting the air in communities like North Minneapolis and other communities around the state?
Yeah, thanks for that question. So the legislation applies to existing permits when they need to renew their permit, or if there is going to be an expansion or a re-permitting process. And that's the way the legislation is written right now. So it doesn't mean that if an existing facility is there that they would not be subject to this. I think I mentioned in the presentation that we do have a facility list. It's approximately 120 facilities in the Twin Cities area, and that list is available on our website, and it does lay out the permittees that could be subject to the rule once it is effective. And so I think to answer your question, will those other sources be considered? That's the entire intent of cumulative impacts, right? Is to look at what are the other sources that exist within the community that are of concern, because our role is to protect human health and the environment. That is our mission as an agency. That is what MPCA is charged with doing. And so the legislature has passed this law, directed us to do this rulemaking so that we can, in fact, exercise our authority to do just that. Exactly how it's going to roll out, I think there will still be some things to be determined. Implementation, will come, but those are all things that we need to hear about to hear, what are the sources that should be considered. And so I think to answer your question, will existing facilities be required? Many of them will. It does depend on the type of permit they have. And it right now is written, the way the law is written is that it's at the point of reissuance or a new permit or an expansion of an existing facility. So certainly many of those existing permittees are going to have to address cumulative impacts over the coming years. And then exactly what that means is yet to be defined, but the idea behind cumulative impacts is just that we are looking at all of those sources that exist, that provide, or that are polluting sources that could impact human health or the environment. Looks like we have another hand up.
Yes, Patty, you can go ahead and unmute yourself and ask your question.
Great, thank you. Was having a little bit of problems there with raising my hand versus giving you the thumbs up. Your last statement made me think, I often think about the National Ambient Air Quality Standards being set to protect human health and the environment. And I'm thinking, how this effort of cumulative impacts will dovetail with those national ambient air quality standards. And I'm guessing, but I'm just curious. So is there going to be an accumulation across multiple pollutants, or will, and maybe you don't know this yet, right? Is the intent that you'll be looking at a summation across multiple pollutants so that it goes above and beyond the national ambient air quality standards? Or will it be on a pollutant by pollutant basis?
So I will say that you are correct in the assumption that we don't really know yet, because we are in that draft, the information gathering state. We're trying to figure out exactly what should be included. So we'll be seeking input and comment on this specifically. But I would invite perhaps one of my colleagues, maybe Hassan, who is an air permit engineer, to further address this question if he's able.
Yeah, hi, Anna. I think it's a really good question, Patty. For folks who aren't in the know about the National Ambient Air Quality Standards, they apply their very small, specific set of pollutants. So, and like Anna said, how this rule might be crafted to contemplate those standards which apply versus some of the other pollutants, whether or not they're hazardous air pollutants that are regulated or they're air toxics. There's a whole bunch of different ways you can talk about and call all of the different things that float about in the air, and how they all sort of play together is exactly what we're trying to figure out here. So there might be some things, maybe there is health effects related to particulate matter pollution that we address through something like the National Ambient Air Quality Standards or something similar to what that analysis might look like. But if there's other stuff, if there's other pollutants that aren't regulated under those standards, what do we do in that circumstance? And that's what we're trying to figure out, what we have to come up with for this rule and how we talk about and think about addressing those pollutants and the impacts that they have. And I think Carrie Carrie, go ahead and add something on air toxics if you like.
Sure. Hi, this is Carrie Palmer. I manage our air assessment section, as you mentioned earlier, and appreciate this question as well, because it does get, as Patty knows, can get pretty complex. And like Hassan mentioned, you know, there's definitely different ways that we could look at this, and one could be a pollutant by pollutant. I did want to mention, you know, currently when we look at air toxics, we do add them up by endpoint. You know, so that means different kinds of health endpoints, whether something causes cancer or affects a different part of people. So we do some additivity and look at those and add things together and look at them together. So that could be another path that we would go. And like Hassan mentioned, I just want to stress that this is the kind of input that we are really looking for. So as much as you can when you're doing your comments, if you can think about, you know, the different ways that pollutants interact. Certainly we're looking at cumulative. So we're looking at more than one thing at a time. And I think that's kind of the point of looking at it in a cumulative manner. But exactly how you do that is what we'll be working on over the next couple of years. And we're really interested in your input for it.
Thanks, Carrie and Hassan, for that additional information. As mentioned, it does get complicated very quickly. So there are a lot of very technical details to work out and a lot of policy details for us to work out over the coming years. So thank you for that information. And then I just want to address, there was a question in the chat referencing the open house meeting, specifically the one that is on the 19th, and whether or not Brooklyn Center and Brooklyn Park have been informed about these. And yes, the meeting itself is being hosted at a public library. And so yes, the cities are aware that the meetings are occurring. And so I don't know if there's any further question about that specifically, but certainly we've done some outreach to let individuals and let the cities know that the meetings are taking place. At this point, I believe we've addressed all of the questions that came in through chat, and I don't see any hands raised. Is there anyone else that wishes to comment or ask a question? Otherwise, I think we'll move to wrap things up. All right, not hearing or seeing any additional questions, I would once again like to thank everybody for your participation here today and remind you that we do have the upcoming meetings over the next couple of weeks, in-person open houses, and we very strongly encourage you to attend one of those if you're able, and to continue to follow this process online by signing up for our Gov delivery list and by submitting formal comments to the docket if you'd like. I'd like to turn it over to Darren just for some closing comments here before we close. So thanks, Darren.
Hi, everyone. Thanks again for today's meeting. This was a good conversation. Lots of folks have questions, and this is a very complicated topic. So again, appreciate everyone's willingness to bear with us and work with us on this as we kind of go through this. Just want to re-emphasize again that this is the start of a conversation over the next 3 years, not the end of a conversation. And so we look forward to 4 more meetings here yet this month, including in 2 days at Metro State and wrapping up in Rochester on the 26th. And then as we kind of move into the development phase of this rulemaking process or regulatory process, there's gonna be lots of opportunities for folks to come together and help us build out and develop all of the pieces that are listed in statute, as well as anything else that's addressed during the open comment period. So again, I want to thank everyone for their time today and hope to see folks at the open houses over the next 2 weeks.
Great. Thank you once again, everyone. I think with that, we will close the meeting and hope to see all of you at a future meeting in person or virtually. Take care.